Section 6A states as follows. With your permission, I'll just read through Section 6A as well. Special provisions as to citizenship of persons covered by the Assam Accord. For the purposes of this section, Assam means the territories included in the state of Assam immediately before the commencement of the Citizenship Amendment Act 1985. Detected to be a foreigner means detected to be a foreigner in accordance with the provisions of the Foreigners Act and the Foreigners Tribunals Order 1964 by a tribunal constituted under the said order. Specified territory means the territories included in Bangladesh immediately before the commencement of the Citizenship Amendment Act 1985. D. A person shall be deemed to be of Indian origin if he or either of his parents or any of his grandparents was born in undivided India. E. A person shall be deemed to be detected to be a foreigner on the date of which the tribunal constituted under the Foreigners Tribunal Order 64 submits its opinion to the effect that he is a foreigner to the officer or the authority concerned. Subsection 2, subject to the provisions of subsections 6 and 7, all persons of Indian origin who came before 1st day of January 1966 to Assam from the specified territory, including such of those whose names were included in the electoral rolls used for the purposes of the general election to the House of the People held in 1967, and who have been ordinarily resident in Assam since their dates of their entry into Assam, shall be deemed to be citizens of India from the 1st day of January 1966. Subject to the provisions of subsections 6 and 7, every person of Indian origin who came to Assam on or after the 1st day of January 1966, but before 25th day of March 1971 from the specified territory, and B, has since the date of his entry into Assam been ordinarily resident in Assam, and C, has been detected to be a foreigner, shall register himself in accordance with the rules made by the central government in this behalf under Section 18, and such authority thereafter in this subsection referred to as the registering authority, as may be specified in such rules, and if his name is included in any electoral roll for any assembly or parliamentary constituency in force on the date of such detection, his name shall be deleted therefrom. Then the explanation. In the case of every person seeking registration under the subsection, the opinion of the tribunal constituted under the Foreigners Tribunals Order 1964, holding such person to be a foreigner, shall be deemed to be sufficient proof of the requirement under Clause C of this subsection. And if any question arises as to whether such person complies with any of the other requirements under this subsection, the registering authority shall, 1. If such opinion contains a finding with respect to such other requirement, decide the question in conformity with such finding. And 2, if such opinion does not contain a finding with respect to such other requirement, refer the question to a tribunal constituted under the said order having jurisdiction in accordance with such rules as the central government may make in this behalf under Section 18 and decide the question in conformity with the opinion received on such reference. Subsection 4. A person registering under subsection 3 shall have, as from the date on which he has been detected to be a foreigner, and till the expiry of a period of 10 years from that date, the same rights and obligations as a citizen of India, including the right to obtain a passport under the Passports Act and the obligations connected therewith, but shall not be entitled to have his name included in any electoral roll for any assembly or parliamentary constituency at any time before the expiry of the said period of 10 years. A person registered under subsection 3 shall be deemed to be a citizen of India for all purposes as from the date of expiry of the period of 10 years from the date on which he has been detected to be a foreigner, without prejudice to the provisions of Section 8. A. If any person referred to in subsection 2 submits in the prescribed manner and form to the prescribed authority within 60 days from the commencement of the Citizenship Amendment Act 1985, a declaration that he does not wish to be a citizen of India, such person shall not be deemed to have become a citizen of India under that subsection. B. If any person referred to in subsection 3 submits in the prescribed manner and form and to the prescribed authority within 60 days from the date of the commencement of the 1985 amendment, or from the date on which he has been detected to be a foreigner, whichever is later, a declaration that he does not wish to be governed by the provisions of that subsection and subsection 4 and 5, it shall not be necessary for such person to register himself under subsection 3. Where a person required to file a declaration under this subsection does not have the capacity to enter into a contract, such declaration may be filed on his behalf by any person competent under the law for the time being in force to act on his behalf. Nothing under subsections 2 to 6 shall apply in relation to any person, A, who immediately before the commencement of the Citizenship Act 1985 is a citizen of India, B, who was expelled from India before the commencement of the Citizenship Amendment Act 1985 under the Foreigners Act 1946 for a year. 8. Save as otherwise provided in this section, the provisions of this section shall have effect notwithstanding anything contained in any other law for the time being in force. It will be seen that as part of the Assam Accord, a huge number of illegal migrants were made deemed citizens of India. It is interesting to note that Parliament has not enacted any law pertaining to refugees from other countries. Refugee status can be granted and has been granted in India through executive orders passed by the central government. In any case, Section 6A did not merely rest content upon granting refugee status to those who were illegal migrants from East Pakistan, but went on to grant them the benefit of citizenship of India, so that all persons who have migrated before 1966 and all persons who migrated before 25th March 1971 respectively were to become citizens of India either immediately or, as is mentioned by the Act, after a period of 10 years, once there has been a determination that they have in fact settled in India between 66 and 71. On 8th November 1998, Lieutenant Governor S.K. Sinha, the then Governor of Assam, submitted an extensive report to the then President of India on the grave threat posed by the influx of people from Bangladesh to Assam. He said, the dangerous consequence of large-scale illegal migration from Bangladesh, both for the people of Assam and more for the nation as a whole, need to be emphatically stressed. No misconceived and mistaken notions of secularism should be allowed to come in the way of doing so. As a result of population movement from Bangladesh, the spectre looms large of the indigenous people of Assam being reduced to a minority in their home state. Their cultural survival will be in jeopardy, their political control will be weakened, and their employment opportunities will be undermined. The silent and invidious demographic invasion of Assam may result in a loss of geostrategically vital districts of Lower Assam. The influx of illegal migrants is turning these districts into a Muslim majority region. It will then only be a matter of time when a demand for their merger with Bangladesh may be made. The rapid growth of international Islamic fundamentalism may provide the driving force for this demand. In this context, it is pertinent that Bangladesh has long discarded secularism and has chosen to become an Islamic state. Loss of Lower Assam will sever the entire landmass of the northeast from the rest of India, and the rich natural resources of that region will be lost to the nation. It was in this backdrop that a writ petition, being writ petition number 131 of 2000, was filed by Sarbananda Sonowal, assailing the constitutional validity of the Illegal Migrants Determination of Tribunals Act 1983 and the rules made thereunder. In a judgment reported in 2005, 5 SCC 665, this court referred to the Assam Accord and to the huge influx of illegal migrants into the state of Assam and came to the conclusion that the 1983 Act and the rules made thereunder operated in the reverse direction. That is, instead of seeing that illegal migrants are deported, it did the opposite by placing the burden of proof on the state to prove that a person happens to be an illegal migrant. The court went on to hold that Article 355 of the Constitution had been violated, inasmuch as the Union had failed to protect the state of Assam against an external aggression and internal disturbance caused by the huge influx of illegal migrants from Bangladesh to Assam, and went on to hold the 1983 Act to be violative of Article 14 as well. Inasmuch as the Act was struck down, and the Immigrants Expulsion from Assam Act 1950, together with the Foreigners Act and Foreigners Tribunal Order of 1964, were now to be the tools in the hands of the government to do the job of detecting illegal migrants who were then to be deported. On 14th July 2004, in response to an unstarred question pertaining to the deportation of the illegal Bangladeshi migrants, the Minister of State, Home Affairs, submitted a statement to Parliament indicating therein that the estimated number of illegal Bangladeshi migrants into India as on 31st December 2001 was 1.20 crores, out of which 50 lakhs were in Assam. Given the magnitude of the problem, a Foreigners Tribunals for Assam Order of 2006 was promulgated, which was again struck down, being found to be unreasonable and arbitrary, and which, instead of expeditiously discovering the illegal migrants and deporting them, again did the opposite